mining law. I should have narrowed that down. It's going to be a discussion of the local agreement and how that has changed from what I call the old law. It's 293 is still on the books, but I call it the old law. And in 295, which is the Ferris mining law. After the zoning draft came out, and there were a few meetings, there was just a lot of misinformation out about local agreement. We really need to know this part of the law because it's going to be such a big part of what we're going to be doing in the future. One of my biggest pet peeves is an error that people have made regarding local agreements. You hear them say, you know, 293 required a local agreement, 295 didn't. That's not true. The language is the same in both statutes. In 293.4.1, and I'm going to paraphrase just for time, a municipality which issues a zoning or land use ordinance, or any municipality in which a portion of a proposed mining site is located, may enter into a local agreement. That's 293, the old law. The language is exactly the same in 295.443. So when you hear people say, oh, they no longer require a local agreement, it was never required in 293 to begin with. Where the wording was changed was in 295.443, parent 1M. There's about 8 provisions that were required in 293 to be included in your local agreement. It says, an agreement shall include the following, and it lists these 8 different things. That was changed to may in 295. Is that a bad thing? I don't think so. I think it gives the county more flexibility in what they want to include in that local agreement. The only thing where I really liked, it said it shall include a provision for amendment of agreement. Now it says may, but having that ability to amend a local agreement, I think, would be mutually beneficial. So I don't see why that wouldn't go in. Another part is in 295.443. It states, a county, town, village, city, or tribal government likely to be substantially affected. And I'm reading on the social media that the word substantially affected was added in the new law. It's the exact same language in 293. 293.33 says county, town, village, city likely to be substantially affected. And it said something about that producing an additional legal hurdle, but it's the same as it was in the other law. There's also a little footnote that's in 293.41. It's a historical reference to a lawsuit. It was Nicolay Minerals Company versus the town of Nashville. And it's a historical reference. That case in front of the Wisconsin Court of Appeals affirmed that that local agreement was a legally binding contract and that superseded zoning. That historical footnote was not included in 295, but it wasn't part of the law. So people are saying, well, this footnote isn't in here anymore, so it took away local control. But that's all it was for the footnote. It's not a historical reference. The other thing I've heard is that the law says that by law, we need to have an adversarial role between the mining committee and the mining company. But I can't find that anywhere in the law. Actually, what the law says is operators and persons applying for an exploration license shall thereafter make reasonable efforts to design and operate mining operations in harmony with community goals and objectives. I don't know why anybody would want to have an adversarial relationship because we probably wouldn't get anything done. So that's another claim that we're supposed to be adversarial. But if it is in the law and somebody points it out to me, I'll stand corrected on that. The only other changes, under 293.41, it is required that there be a public hearing on local agreements. That's no longer required under Chapter 295. However, all of our zoning goes to a public hearing, and I'd be very surprised if our local agreement didn't. The other thing that's no longer required under 295 in 293 it states, a state agency shall assist a county, town, village, city, or tribal government in enforcing those provisions of a local agreement that are within the expertise of the state agency. That did not transfer over into 295. So there's only 3 changes were made. Those 2, the public hearing, the state agency assisting municipalities, and that one place where you're no longer required to have those provisions, but you can put them in if you want. Those are the only changes. So be sure you're aware of that. When you hear people say, well, they don't require a local agreement anymore, they never did. It's always been an option. They may do that. So, any questions on that part of the law? It's really very short. There's not a whole lot to it.
If we have a local agreement, we can have a public hearing if we wanted to,
yeah,
right?
we can.
Yeah.
We're not required to, but we can. I'd be surprised if we didn't. But